California task force to study and develop reparation proposals for African Americans. Content warning. It contains discussions of racial discrimination, sexual assault, torture, lynching, and other forms of extreme violence. Contains unedited historical quotations and photographs of white supremacist hatred, torture, lynching, autopsy, and other forms of graphic violence.
In the brief period of Reconstruction following the end of the Civil War until the 1870s, radical Republicans in the federal government passed laws increasing African Americans' economic and labor freedom. This included rights to change employers, keep a portion of crops grown through cooperative labor. Locations 83, but this progress was temporary. The Union Army withdrew from the South, as discussed in chapters 2, 3, and 4 on enslavement, political disenfranchisement, and racial terror, respectively. States passed laws and white Americans used racial terror and violence to prevent African Americans from voting. The Southern Democrats took back control of state and local governments across much of the South and built a power base in the federal government. 84 in the South. Local governments passed laws that created a formal, legally enforced system of segregation. 85 The federal government supported this system. Series of Supreme Court decisions culminating with Plessy v. Ferguson's official acceptance of separate but equal Jim Crow segregation regimes in 1896-86. Segregation affected all aspects of African Americans' lives, including voting, marriage, education, transportation, access to public accommodations, and labor and working conditions. 87 For example, South Carolina passed a statute that essentially required employers to create two separate workspaces. Forbid white textile workers from working in the same room or using the same entrances, exits, pay windows, doorways, stairways, or windows at the same time as black workers. 88 Black textile workers in South Carolina could not use the same water bucket, pails, cups, or glasses as white workers. 89 Not only did such laws directly regulate the labor of African Americans, they also made it more expensive to hire black workers when such additional facilities were required. 90 In order to be compliant with state law, would need to pay twice for compliant facilities if they hired any black workers. 91 Many employers simply refused to hire any black workers. 92 As a result, most of the jobs available to African Americans were menial and service jobs. 93 State and local governments' refusal to enforce the economic and civil rights of African Americans in contract and employment disputes allowed white Americans to exploit and discriminate against African Americans. African Americans in the South mostly remained in agriculture. Sharecropping or tenant farming system. 94 Sharecropping and tenant farming emerged in the late 1860s and lasted into the 1940s. Workers to agricultural work and rendering them unable to pursue other opportunity. 95 A sharecropping or tenancy arrangement typically involved black workers and tenants paying rent to a white farmer while living and working on the rented land. The tenant farmers purchased supplies, including fertilizer and tools, on credit from plantation stores that then attached significant markups to the supplies and charged high interest rates, often locking the tenant farmers into a permanent state of debt. 96 Tenants were required to pay off all debts before leaving the farm. Enforced these requirements with threats of violence. 97 For decades, federal authorities did little to limit peonage, even after the Supreme Court declared the practice unconstitutional. 98 With Jim Crow laws, businesses would need to pay to erect segregated workspaces for blacks, thus many employers simply refused to hire any black workers. As a result, most of the jobs available to African Americans were menial service jobs. 10. Labor and hindered opportunity. Sharecropping system also exploited poor white farmers. An added layer of racial terror plagued black sharecroppers, with no hope of government or legal protection in the South. An African American challenged a white American at the risk of severe violence, or death. 99 For example, in 1948, Americans beat a black tenant farmer in Louise, Mississippi, because the black farmer had asked for a receipt after paying for his water bill. 100 If a black farmer tried to sell extra agricultural product without the landlord's permission, whipped or killed 101, they could never leave as long as they owed the master. That made the planter as much master as any master during slavery, because the sharecropper was bound to him, belonged to him, almost like a slave, the grandson of a sharecropper told Isabel Wilkerson, the Pulitzer winning journalist and author of both The Warmth of Other Suns, The Epic Story of America's Great Migration and Caste, The Origins of Our Discontents 102. Reason for preferring Negro to white labor on plantations is the inability of the Negro to make or enforce demands for a just statement or any statement at all. He may hope for protection, justice, honesty from his landlord, but he cannot demand them. There is no force to back up a demand, neither the law nor public opinion. Even the most fair and most just of the whites are prone to accept the dishonest landlord as part of the system, wrote anthropologist Hortense Powdermaker 103. Where in the country, the Great Migration, as discussed in detail in Chapter 1 and 5, brought African Americans from the South to the North, Midwest, and West, blacks, though native-born, as the poorest people from the poorest section of the country with the least access to the worst education, wrote Wilkerson 104, largely excluded even from the better paying jobs and even the menial occupations. Workers in the North and West earned the least money when compared with white recent immigrants at the time. 105 in 1950, African Americans in these regions had an annual income of $1,628. 106 Italian immigrants made $295, Czechs made $2,339, Poles made $2,419, and Russians made $2,717. 107. Still well into the 20th century, black women could mostly only find work as domestic servants for white employers. 108 following the Civil War. Opportunities opened up for women in the fields of teaching and nursing. 109 black women who entered these professions could only work in segregated facilities. 110 A few decades later, private employers hired mostly white women as receptionists, department store clerks, and machine operators. 111 black women took over household work as white women, including white immigrant women, moved into these better paying jobs with set work hours. 112. The North and the South, black female labor participation rates were double those of American-born white women and triple those of immigrant women. During the first half of the 20th century, the number of white female domestic workers fell from 13 million to 542,000. Women went from accounting for % of household workers around 1900 to about 60% of household workers at the end of World War II. 113 Some black women working as servants lived in their employers' homes and were on call 24 hours a day. 114 Other black women resorted to what was colloquially referred to as slave markets. Gathered on street corners early in the morning to wait for white housewives to bid on them for as little as 15 cents an hour. 115 One woman at a Chicago slave market reported that she made 50 cents a day, the same money as she would earn for picking cotton in the field. 116 Each of these eras, and through to the present, civil courts did not protect African Americans to the same degree as white Americans. However, one scholar has found evidence that African Americans used civil courts in one district in Mississippi before the Civil War to vindicate their rights in claims over contracts and wages, and found that in many instances these litigants won their cases. 117 Discrimination remained built into the law. Several states, including California, prohibited black persons from testifying against those who were white. 118 African Americans additionally faced de jure and then de facto exclusion from juries. 119 Some states explicitly banned African Americans from jury service, while others tied jury service to voting. Limited to white men. 120 Exclusion continued by other means after the Supreme Court in 1879 ruled that a West Virginia statute limiting jury service to white men violated the 14th Amendment. 121 Other forms of discrimination, including segregation, also limited access to justice. 122 In addition to the racial terror discussed in Chapter 3 and the political disenfranchisement discussed in Chapter 4, the civil court system also contributed to failure to protect African Americans against the theft or government taking of property. Has been a source of income and sustenance. For example, in 1856, an enslaver, Thomas Howlett, directed that his plantation be sold and the proceeds given to his enslaved African American workers. To be freed upon his death. 123 Two courts upheld Howlett's will over the challenges of Howlett's white relatives, but the formerly enslaved workers never received the proceeds from the plantation sale. 124. Another example, in 1964, Alabama sued two cousins, Lemon Williams and Lawrence Hudson, claiming that the 40-acre farm that the family had owned and operated since 1874 belonged to the state. 125A state court judge ordered Lemon Williams and Lawrence Hudson off the land, though, in the same courthouse. Journalists found tax and property records showing that the family owned the farm. 126. To justice, including those outlined above and in Chapter 11, continue for African Americans today. While the relationship between race and the civil justice system is under-researched, studies thus far indicate that African Americans underutilize the civil justice system, including in the area of labor and employment. In a 2016 study conducted by legal scholar and Professor Sarah Sternberg Green of low-income minority group attitudes toward the civil justice system, African American respondents were less likely than white American respondents to have considered seeking help for their civil legal issues. Because of distrust in the legal system. 127 This lack of trust often stems from prior negative experiences. 128 Black people are more likely than white people to experience biased treatment in the judicial system. Who experience discrimination are more likely to anticipate and perceive discrimination across institutional contexts. 129 There is also evidence African Americans are reluctant to complain when they perceive discrimination or experience other grievances. 130 Additionally, social science research shows that litigants may find their attorneys through their professional networks, and African Americans have more limited professional networks. 131 Of the civil justice system and lack of access to justice have particular impact in the area of labor and employment. African Americans hold a significant share of low-wage jobs in sectors in which wage theft is prevalent. Available evidence indicates that African Americans rarely bring wage theft claims. 132 African Americans are more likely than white Americans to file a discrimination lawsuit without a lawyer. 133 A 2010 study found that African Americans are half as likely as white Americans to have a lawyer. 134 In general, 5% of worker discrimination claims go to trial and result in a ruling for the plaintiff. 135 And self-represented litigants are significantly less likely to achieve a favorable outcome in a discrimination suit. 136 In the first half of the 20th century, the number of white female domestic workers fell from 1 million to 542,000, while black women went from accounting for 30% of household workers around 1900 to about 60% of household workers at the end of World War II. Some black women working as servants lived in their employers' homes and were on call 24 hours a day.